not, but there may be a subtle distinction between a draft report and a report drafted by somebody that's re-engineered by somebody else. The draft report is, these are my thoughts, these are my opinions, these are my conclusions. Adam, I'm sending them to you on a preliminary basis for us to discuss them. Let me know what you think, and then I'll, issue the final version.
Please don't do that. Any of you, don't do that.
That's an issue in that draft report you can't ever get away from. You can't destroy it. It's got to stay in the file. If you do destroy it, that makes for really good cross-examination and may lead to really dire consequences. There's a law about spoliation, which is destroying evidence, and adverse inferences that can be drawn. So destroying it is bad. Keeping it in the file is just plain old fun for lawyers like me on cross-examination, because then you can compare the draft to the final and see that, when it was sent to Adam in draft and it said this may have caused this problem in draft, and then the word may is removed and now it says did cause the problem, then I can have a lot of fun with the expert on how the word may got changed to did after you spoke to the person who hired you. And that evil person caused you to change that. It has some severe blowback on that other lawyer, even if that lawyer didn't do anything wrong.
And that's what's really important about that, and sometimes clients don't understand this either when we talk about credibility issues and what they mean. One little change in a report of the variety that Eric described, or even something a little more innocuous, in and of itself might not mean anything. Nothing really turns on it. And you might think, well, this isn't a big deal. But it does two things. It taints the rest of your report. So the one little thing, a list of 10 conclusions that you've come to, one conclusion that was changed slightly doesn't just taint that one conclusion, it taints all of the conclusions, and it also taints potentially everything that comes out of the mouth of the lawyer that is calling you to give evidence.
I love that when it happens to the other side. I don't like it much when it happens to me.
So that definitely can become a serious issue. I mean, the one thing I would say that I don't mind as much, and I see it a lot more, is draft accounting reports. Accounting reports are really nothing more than math. Math based on assumptions.
Sometimes poor math.
Well, that's true too. So, I don't think you've got the same issue with an accounting report where the accountant says, yeah, I had a draft report, I discussed it with Mr. Wagman, we had some assumptions that we made, we've changed the assumptions, but the bottom line is the assumptions are meaningless because what's important here is what the judge or the jury finds to be the facts, and then I'm just going to show you how to do the math based on the facts that you've found. I've given a couple of scenarios, we worked out those scenarios to try and get something reasonable to present to the jury, but the reality is, jury, you're going to do the math anyways. That's very different from the types of reports that most of the people in this room are going to be doing.
And I would put engineering in the same class.
Yes, correct.
Engineering and accounting reports, draft, not nefarious necessarily. Although, again, it gives rise to cross-examination on, so you started out with this assumption, and then after you spoke to Mr. Wagman, you changed that assumption, and now you're assuming this. Now, let's look at why you changed that assumption. And that may give rise to some useful cross-examination. Wasn't the first assumption you made a reasonable one? That was your idea, wasn't it? And now you've changed that assumption because Mr. Wagman says he didn't like that assumption as much as this next assumption. Okay, again, it's not nefarious necessarily, but it has potential ramifications that in the hands of a skilled cross-examiner can lead to some points to be made.
I think we want to move on in a minute or two to some other...
I was just going to raise one other issue on this point, and that is the relatively new advent of Rule 53, of the Form 53 from the Rules of Civil Procedure. Every expert has to sign one. I'd imagine that anybody who does expert reports has seen them. If they haven't, they ought to familiarize themselves with them. It requires everyone who generates an expert report to indicate that they understand that they have an obligation, first and foremost, to the court, to be neutral and to represent the interests of justice effectively, not the interest of the party that's retaining them. And that is a real, it's supposed to be a climate change, although many would argue that it should have always been the case. It's especially problematic for people who are accustomed to being an advocate for their patient. If you're a GP, there's a real dichotomy there in terms of the GP, the OT, the treating practitioner, if you will, who is there to assist their patient and yet is supposed to be providing some neutral document to the court. I'm curious to know what your views are in the context of these treating practitioners and their obligations vis-a-vis that patient and that Rule 53 form.
Well, and what's interesting is the Rule 53 form talks about being retained and what purposes you've been retained for. And a lot of treating experts will say, well, this form doesn't really apply to me. I wasn't retained for the purposes of doing something in litigation. I'm the person's treatment provider. And, you know, we're still relatively early in the case law coming out of Rule 53. What many of the judges are saying fairly publicly is, look, I don't necessarily care if it is the Form 53 that's signed, but you got to give me something. So if a doctor, if a GP, if a treating OT needs to change that form and say, you know, cross out the line I was retained for the purpose of and say, you know, I am this person's treatment provider, and yet I still understand that my duty is to come to court to provide an unbiased opinion and to provide evidence that will assist the court, not one party or the other, then a lot of the judges are saying we would accept that as a proper Form 53 because it goes along with the spirit of the rule, which is this idea of neutrality. But, you know, so if you've got questions about filling out that form, consider the idea of amending it slightly so that it accords with exactly what it is that you've been retained to do. The other thing is, don't sign the form blindly if it's not accurate. There was a situation that has been fairly well reported, one of the leading decisions on Form 53, where some AB doctors were going to give evidence, and there was some issue about whether they could or couldn't, and did they sign Form 53, and so what they did is they just signed them blindly. And the judge looked at it and said, well, but this isn't right. You weren't retained for this purpose. You never did a report in this action. That's not what you're being called for. Why would you have even signed that in the first place? And so, you know, you've got to take a look at that form and make sure that what you're signing, in addition to your report, of course, is true and accurate. Maybe just one last point before we move on, if you have something to say, and I just wanted to add a little bit about witnesses.
Yeah, I was just going to say that I don't necessarily agree with the belief that an amended Form 53 would be well received by a judge. I don't think it would be. But there is also room for the treatment providers to give evidence that may not fall within the Rule 53 ambit as expert evidence. You're giving evidence of a historical nature of treatment. The challenge becomes whether your opinions become admissible. And, you know, as a general proposition, the opinions of those treatment providers have been given less weight than those of medical legal consultants in any event. And for the most part, without disparaging any treatment provider, that may not be wrong in the full context of a trial. So, you know, this is what they complained of, this is what I did for them, this is what I recommended. That's the evidence that you're probably going to get from these people and probably is what you want.
Yeah, and there's a lot of case law all over the map out there about whether, in fact, treatment providers even have to sign Form 53s, you know, who has to sign them, under what circumstances. So it's not all settled law yet. Just a couple of quick suggestions or points for all of you to consider out there when writing reports and preparing to give evidence. You know, in order to make sure that you're unbiased and you've given, you know, you've got a good report out there, you've got to get everything. You've got to get all the documents. As a lawyer, you've got to give all the documents to your people writing reports, including treatment providers. Failure to do so is going to be fatal to their evidence being accepted, because Eric's going to pick up on it immediately and cross-examine on it. Don't pick and choose. Give them everything. And as a report writer, review everything. not just paying lip service, not just adding as an appendix, but make sure that you've read it, make sure that you've commented on those important things, and make sure that you don't just quote those parts of the reports that are helpful and supportive of what you have to say. It's amazing how many defense reports I get where they pulled the negative quotes out of all of the various reports and ignored the conclusions that say, you know, yes, the plaintiff has these various problems. And it becomes very clear that all that they're trying to do is advocate for a side as opposed to provide this kind of biased, this unbiased, opinion to help the court. It becomes very obvious on the face of it. The other thing is your demeanor in the witness stand. There's nothing better for a lawyer than to have a wonderful doctor get up on the stand, be very nice to Eric, be very open, open body language.
That's rarely happens.
Yeah, exactly. And then immediately, as soon as I stand up to ask questions, their body language changes, they become dour, and
that often happens.
It always happens, and it's my wife mostly. You should point this out as an advocate. Wait a second, doctor, 2 minutes ago, shockingly, when Mr. Grossman was asking questions, you were wonderful and nice, and all of a sudden, did you notice how your tone changed? Did you notice that, are you here just to help Mr. Grossman?
Well, you're here to trick me, Mr. Wagman, yes, and that's why I'm a little bit concerned.
Yes, which of my words did you not understand? I can speak more slowly for you.
So again, you really do have an obligation to be fair, and you should take it seriously for those people out there. Let's talk about some professionalism stuff.
I'm against it, but okay. All right. So people often comment about the personal injury bar and how it interacts with each other. I often get comments from, or I often overhear comments because they're rarely directed to me, about how could I be effective in dealing with opposing counsel if I'm friendly with them. There are concerns often raised by my clients, and I imagine also by Adam's clients, probably more so by Adam's clients who are less sophisticated about, well, wait a second, you seem like you're getting along with opposing counsel, and aren't you in some way compromising my case? Well, the opposite is actually the case, in that if you aren't getting along, you aren't doing an effective job for your client. If you are just butting heads with opposing counsel, all you're doing is costing your client money because you're fighting over things that you don't need to be fighting about. You aren't narrowing the issues. You aren't coming to agreements on things that reasonable people would come to agreements on, and you end up having much more protracted, more expensive battles, and end up fighting and potentially losing parts of cases that you have no business fighting about in the first place. So, what's your take on this whole professionalism, getting along with others in the sandbox?
Yeah, singing Kumbaya together, holding hands at mediations, it's wonderful. Look, some of it has to do with personality style. I am a bees to honey type of person. I really do believe that I get better results for my clients by helping to make the other lawyer and the insurance adjuster want to help my client as opposed to want to fight me at every single step of the way. But again, that's my personality style, and it's okay to perhaps be more aggressive, less agreeable under certain circumstances, because every case is different.
Well, those are easy.
Yeah.
You get along with me, I get along with you. What about the a-hole that you're up against tomorrow?
Yes.
Do you know about my mediation tomorrow?
Just a guess.
Look, something that a mentor of mine sitting fairly close by taught me a long time ago is that the louder you speak, the less people tend to listen. So you'll notice that sometimes Jim speaks like this, and it makes it a little bit harder to hear him, but you have to listen very carefully.
I don't even bother trying.
Yeah. But it's true. And so, the yellers, the screamers, they get tuned out. The points get completely lost when someone opens at a mediation, when someone opens at a trial and they're yelling and screaming, they just watch too much television. That's the bottom line. It's poor advocacy, but it also, to some degree, will go against both your client's interests and the rules of professional conduct.